A secured transaction is one where the buyer offers some kind of collateral to guarantee their payment. If the buyer doesn't come through with the payment they need to make, the seller can either keep the collateral or sell it and apply the proceeds to the balance it's owed. Secured transactions have 5 major elements to them: a debtor who owes money, a secured creditor who the money is owed to, the collateral, which is the asset that's being offered as a backup plan in case the debtor doesn't pay, a security agreement, which outlines the terms of the collateral arrangement, and the security interest, which basically refers to the creditor's right to take or sell the collateral property. Like most of the other topics covered in this chapter, secured transactions are governed by the Uniform Commercial Code, or the UCC, Article 9 to be specific. There are 2 main types of secured transactions. A pledge is when the creditor keeps the collateral property until the debtor makes payment or performs whatever was promised. Once the debtor does that, the collateral property is then given back to the debtor. A chattel mortgage is when the debtor can hang on to the property and use it even while they haven't fully performed or paid yet. If the debtor falls through on their promises, though, the creditor has the right to take back ownership and/or title to the collateral property. A good example of a chattel mortgage is a personal car loan. The bank will lend you money with the car as the collateral, but they will let you use the car as long as you keep making payments. If you stop, though, they'll definitely make you hand over those keys. There is also a special type of chattel mortgage called a conditional sale. This is where you buy something and the seller is the one financing the transaction, so you owe your payments to the seller. The same rules apply, where you can keep the good as long as you make payments, but the seller can take the item back if you fail to make your payments as due. Going back to our car loan example, if the dealership you bought the car from is the one offering you the loan instead of a bank, that would be an example of a conditional sale, since the seller of the item, the dealership, is the one financing the transaction. Virtually anything can be collateral. Before your exam, you'll want to remember the 5 most common categories of collateral. The 5 categories are consumer goods, equipment, which refers to items used for business or government purposes, farm products, such as livestock or produce, inventory, or property on paper, which refers to any document proving you have rights to personal property. The process of legally creating a security or collateral interest in a property is referred to as attachment. In other words, only after you've gone through the process of attachment do you then have creditor rights to a property, meaning you can repo it or sell it if you need to, even though you're not the property's legal owner. In order for an attachment to be valid, there are 3 essential elements. First, the debtor and creditor have to have a security agreement in place that they mutually agreed to. Second, the creditor has to give some kind of consideration or something of value in exchange for those collateral property rights. Usually, their consideration is the money they're lending. Third, the debtor has to actually have ownership rights to the property they're pledging as collateral. In other words, you can't use someone else's property as collateral for your loan unless you have that owner's consent and involvement in the security agreement. An important thing to remember is that attachment does not protect the creditor from other parties. So if the debtor owed a bunch of other people and used the same property as their collateral, there's a possibility that the creditor will have to fight with other people for the proceeds from that one collateral asset. To give themselves added protection, a creditor could do something called perfection, which is basically a more formal process of attachment that gives you higher priority when it comes to the collateral property. If a collateral property gets sold, the money is first used to pay off any creditors that have a perfected security interest. After those claims are settled, if there is any money left over, the remaining funds get split up between any attached creditors who did not go through perfection. Having a perfected security interest is definitely preferable because that gives you a higher priority when it comes to collecting against the collateral. Here's how you go about getting a perfected security interest. To get a perfected security interest, you need to file a financing statement or agreement with the appropriate court. The financing statement has to have three elements: the names of the debtor and creditor, the debtor's signature, and a general description of the collateral property. The financing statement is good for 5 years, and you can renew it as many times after that as you want for 5 more years at a time. Once you have a perfected security interest, you have a higher priority than almost anyone else. There are, however, a few parties that would still have priority over you in your perfected security interest. Those parties are holders in due course, anyone with an artisan or mechanic's lien, and anyone who buys the collateral property from the borrower so that they can resell it, assuming the buyer didn't realize that the sale violates the borrower's security arrangement with a creditor. To protect the collateral property, it's pretty common for creditors to require that a borrower buy insurance for it. Once the debt is paid off, the debtor can ask the creditor to provide what is called a termination statement, which basically says that the debt has been satisfied and the creditor no longer has any rights to the collateral property. If the debtor messes up in a way that gives the creditor the legal right to close in on the collateral property, that is referred to as the debtor being in default. Not making your payments is the most obvious and common way to be in default, but other ways to be in default include if the debtor doesn't get insurance on the collateral when it was required, if they file for bankruptcy, if the collateral gets lost or destroyed, or if the debtor moves the collateral to a place where it's not easily accessible by the creditor. Once a debtor is in default, a secured creditor can close in on the collateral property in a number of ways. They could forget about the collateral altogether and just sue for the full remaining amount of the debt owed. They could also do a strict foreclosure, which means the creditor keeps the collateral and considers the debt settled in full. Keep in mind that strict foreclosure is not allowed on consumer goods whether debtor has already paid at least 60% of what was owed. That's because it wouldn't be fair for the creditor to take back the item and give you no credit for it when you already paid most of what was owed. Also, if the creditor does not have possession of the collateral property, they're only allowed to repossess the item without getting a court order first if they can do so without breaking any laws. For example, if the creditor has to trespass to access the property, they would need to get a court order before they can lawfully repossess the item. Another option the creditor can go with is to sell the collateral and keep the proceeds to pay off the debt. Finally, the creditor can choose to just dispose of the collateral property however they see fit.